Hey there, welcome to Help Solve the Case. I'm Christine Burke. Today, we're going to talk about the Matthew Nilo case out of Massachusetts. Woman fought off Boston serial rapist, how her glove led to a suspect years later. The glove a woman used to fend off sexual assault assailant was used to help identify a suspect in the assault and three others that occurred in a North Boston neighborhood over a decade ago. And we're going to read these because I don't know what's in these. I haven't read them. New Jersey attorney Matthew Nilo, what kind of attorney is he? Do we know? 35, stands accused of raping four women in the Terminal Street, Charlestown area in 2007 and 2008. Over a decade since the assault occurred, developments in DNA technology, blah, blah. One occurred December 23rd, 2008, when a 44-year-old woman was jogging near Terminal Street in Charlestown when a man ran up behind her and put his arms around her upper body in a bear hug. The man put his left hand inside the victim's pants and underwear, touching her vagina. When the victim screamed, the man said, "I have a gun," numerous times, according to prosecutors. The victim fought back with her gloved hands and poked the man in his eyes. After the attacker ran, the victim returned to a home, called 911 to report the assault. As part of the investigation, her clothing, including her glove, I guess they only took one, was taken as evidence, but no forensic link was established at the time. In 2022, we heard that police use new forensic investigative genetic genealogy to help narrow suspects. This technology allows investigators to search publicly accessible DNA databases populated only by data that users have chosen to make available. I'm going to leave. He was placed under surveillance in May. The glove that the December 2008 assault victim used was sent for forensic testing at a private lab. Male profile was found. 314 times more likely to belong to Nilo than any other male in the population. Look at the difference in that number. I'm going to have to ask my expert on that. FBI agents obtained several utensils and drinking glasses Nilo used at a corporate event. I think that's when I first heard about it. From one of the glasses, they got the male DNA profile. Did anybody else touch his glass? Defense questions, police questions. In the early hours of August 18th, hopefully they would have done STR. Once he was arrested, they would have taken his DNA and compared it and got a second comparison. We'll see. So they did what's called surreptitious DNA collection. In the hours of August 18th, the 23-year-old woman, we read about that one. They got the DNA from that. It went into CODIS. Over a decade later, Nilo's DNA would match the DNA gathered from the three sexual assaults. He was arrested in May 2023. The New Jersey lawyer pleaded not guilty. Bail was set at $500,000, and he was supposed to be there for a bail hearing on June 12th. All right, trying to get. We may be out of order now. DNA grabbed from drink glass ancestry database at center of Boston rape case. I want to go back right here. They said here, because remember I asked this question. They're reviewing thousands of messages from BPD and Boston rape case. They're still making their way through more than 45,000 communications between Boston police investigators about the investigation into Matthew Nilo. Let's read that one. A New Jersey lawyer accused of assaulting. Oh, now it's 8 women. Now it's 8 women. In a brief court filing asking to continue a hearing in Nilo's case, Assistant District Attorney Lynn Feigenbaum said the 45,000 communications received by prosecutors since Nilo's last court date total 500,000 pages. So far, they have turned over 1,200 documents to attorneys for Nilo, totaling 9,000 pages. Feigenbaum said there are still more than 30,000 communications to be reviewed by prosecutors that may be turned over to Nilo's defense. He's charged with the rapes and assault of 8 women. That doesn't stop. And here it says, this is a no-no. Police identified Nilo as a suspect after running DNA obtained from his accuser's rape kits through MyHeritage, an online ancestry database. And I don't know who did this, but this is the drama. This is the bad stuff. I don't know if they obtained permission. I've heard this word, that they obtained permission to go into MyHeritage and if it's the feds or anybody receiving federal money per the 2019 DOJ guidelines, should have to adhere to those guidelines. And there's only 2 law enforcement approved where users opt in to the law enforcement databases. They not only opt in to share their DNA with others, but they opt in specifically for law enforcement access. And those are the databases that are supposed to be used. In My Heritage does not have a I will cooperate with law enforcement portal. And to my last checking, I haven't seen anything that says we will cooperate with law enforcement. And when you use this software, we will cooperate with law enforcement. Now, did they have a warrant? We don't know what they've had, but there's been nonsense since the beginning. And I don't agree with the ends justify the means. So we'll continue. This is part of what I want to talk about. The DNA, because I have heard rumors and I'm not sure exactly what they did. So we're going to see what they're saying here. The DNA led police to Nilo, whose DNA was recovered from drinking glasses and various utensils he used at a corporate event. So this says drinking glasses and various utensils. Prosecutors wrote in a statement, DNA from one of the glasses matched the suspect profile 314 times. It matched the suspect profile and a glove. Nilo's lawyer, Rosemary Scapiccio, had made the DNA evidence central to Nilo's defense. It appears there was a warrantless search of a DNA genealogy database prior to Nilo's arrest or indictment, for which Nilo did not contribute. We're going to be talking about that too. She wrote in a court filing in 2023, and that's what I want to find, those filings, adding that Nilo knew of no family members who contributed to the database. Who cares? I know we care, but let me explain this. I can find it down to your 5th or 6th or 18th or 15th cousin. It doesn't matter that his family members were not in there. Your family member, let me correct that. Your family members are in the database because those are your relatives. You're not going to match with people who are not your family. So those are his relatives. Whether they're in his immediate family or not, those are his relatives. Ain't no way around it. So they're in there, and we'll talk about that. Let's get to more details here. All right. Let's just click on these. I don't know. I don't want to go on forever and ever. I know we've been talking for a while. The public should be terrified, lawyer decries. I don't know when this is February 13th of this year. A defense lawyer representing a New Jersey lawyer accused of attacking several women in Boston more than a decade ago accused federal investigators of hiding information she believes would be critical to the defense. Now, where have we heard that before? Brian Koberger? We've heard that. During a hearing in Suffolk Superior Court Wednesday, attorney Rosemary Scapiccio, correct me, I don't know how to say that, urged the judge to force prosecutors to find more information about how exactly Matthew Nilo's DNA came to be seized from a drinking glass and utensils he used at a private event in 2023. We're not talking about the database here. We're talking about how the DNA came off of the drinking glass and the utensils, although it says drinking glass and utensils, but we've heard of drinking glass. So if chain of custody is so important here, I'm trying to think of an example to give you. If I mistakenly left my cell phone, I'm trying to give you an example. If I mistakenly left my cell phone in a hotel room and checked out and flew across the country, and the police needed it somehow, and they took it and they were going to use it in evidence, a defense challenge like the Miss Scapiccio is making would be who handled it, who could have altered it, who could have touched it. And you have to document that in the chain of custody. Just because it comes from a private party does not make it any different. So, for instance, if the police were to seize this off the desk in my office, the officer that took it and touched it would have to write that he was the first one to take it, and then he gave it to officer's chain of custody, who then the evidence tech signs it in, or the lab signs it into the evidence locker, then the lab tech checks it out. Boom, all those people. That's what chain of custody is. So, did it just show up at this private lab? And remember BK's case? That's proprietary. We don't. Do you remember the poor detective on the stand saying, I didn't know anything? They just called me and said, Brian Koberger. No reports, no nothing, no bench notes, no nothing. Again, I want to get these pleadings because I think this is very important. I'm talking about constitutional issues here. On the one hand, I want to protect this amazing tool, but on the other hand, we need to make sure that stuff is being done properly. So we're, as always, taking both sides. So she filed a motion to suppress the seizure, which I have not seen yet, and the subsequent search of genealogy databases. So if you guys see that anywhere, let me know. She told Judge Sarah Wayland Ellis that people working at the New York City restaurant could be witnesses for the defense at a hearing on the motion. You bitch a boopy. The manner in which these items were delivered to the FBI, delivered, that sounds like later, and the manner in which the FBI said they observed things is the whole purpose of the hearing. Prosecutors have said the FBI, which conducted the seizure at the request of Boston police, did not, Sergeant Burke is angry, did not document the names of the waitstaff working at the restaurant where the event was held. That sounds like they didn't get a list of whoever was working. But who handed it to the Fed? Did they drop it off later, like a to-go? Sound like Nancy Grace, don't I? Oh my goodness. God help us. Let's keep going. Not going to jump to conclusions. Scapiccio, I'm going to butcher her name. Scapiccio struggled to believe that was true. I struggled to believe that's true too. Got a bunch of dummies working there then. The idea that nobody took any notes about that, what their names were, what they look like, is just beyond, probably said, the pale. I've been involved in a lot of federal cases. They document paper clips on the floor. Trained officers, y'all know, it doesn't have to be a federal officer. Y'all know about chain of custody. Goodness gracious. When you read a report and a report from a police officer has supervisor approval, most times it's signed right on the bottom of it. This is not new to anybody. God, I gotta stop sounding like her. This is her statement, not my statement, but clearly there's something wrong they feel they need to hide, she added in an interview following the hearing. Transparency, people. If you have done nothing wrong, then you should be like, come check my books. Let's go. Here you go. Ellis, the judge, noted Scapiccio's objection, but declined to make a ruling forcing prosecutors to do more than they already had. This crap has to stop. She set a hearing on the motion to suppress for June 16th and told Scapiccio the hearing could be continued if there was testimony that required further investigation into what happened at the restaurant. I don't know what happened to that. Nilo's case has ground to a halt as both sides continue to litigate the DNA issues. Following a discovery request from Scapiccio, prosecutors turned over about 10,000 pages of emails that showed coordination between law enforcement ahead of the seizure. My procedure expert. I'm like, yes. Nilo is accused of assaulting 4 women in the Terminal Street area of Charlestown between August 2007 and December 2008. Prosecutors say he also attacked several women in Boston's North End around the same time. Because, see, that should be prolific. I want to read more about that. The DNA evidence is critical to the case against Nilo. Prosecutors identified Nilo as a suspect. Nilo's DNA was then obtained from a fork, a napkin, and drinking glasses he used at a corporate event in New York City in April 2023. He was arrested the next month. The DNA from those utensils matched the DNA from the rape kits, according to the government. Nilo's lawyers have said he does not know family members who submitted. They're all your freaking relatives. Sorry, you lose on that one. Without the DNA evidence, Capiccio has sought to suppress. Prosecutors have no case. That blows for them. If we win the motion to suppress, then there is no evidence, she said in an interview following the hearing. Don't rely just on this stuff, man. You either do your stuff right, dot your I's, cross your T's, babe. If we win a motion to suppress, there is no evidence. No witnesses identified Nilo as a suspect, and the police, oh my God, the police never put him in a lineup or photo array. God, Police 101, people. You cannot rely on one thing, specifically if this stuff gets suppressed. This is why I call it forensic genetic genealogy, because it's forensic. It means it's going to court, which means litigation, which means motions to suppress, which means impeachment. You could lose any parts in this process, and you have to front load your case. Oh my freaking goodness. Who did that? Who did that? I was taught that. We did have photo lineups in the dinosaur days. Just saying. During the hearing, the prosecutors renewed their request for a buccal swab from Nilo. So does that mean that they've never confirmed it? Scapiccio argued that no such swab should be done until after the DNA discovery issues are resolved. So it sounds like the forensic genetic genealogy is the only identification, and they have not done confirmation STR, which I believe is a thing in those DOJ guidelines. That's interesting. Let me know if you've read that somewhere. After the hearing, Scapiccio said it was premature to raise the issue of the buccal swab and deemed it a red herring. Why would I let my client give their DNA when the government wants it? This whole case regarding DNA has been a lie. Ooh, this is so interesting. Scapiccio has asked the lab be delayed until the motion to suppress is decided. He's a lawyer, remember? What kind of law? We don't know. Nilo's is one of several long open cases in Massachusetts to lead to charges using investigative genetic genealogy, or IgG, whatever. Suffolk County prosecutors brought charges in 2 decades-old murder cases in recent months, including one in where they obtained a Jamaica Plain man's DNA after seeing him spit in a parking lot. But Scapiccio, what happened with that one? Do you guys know what that one is? Scapiccio said Nilo's case enters uncharted territory the closer he gets to trial. Only one other IgG case has gone to trial in the Bay State, that of Marvin Skip McClendon, who was accused of killing 11-year-old Melissa Tremblay in Lawrence in 1998. He was eventually acquitted. Got to look at that one too. She drew a distinct line between the actions undertaken by investigators in Nilo's case and other similar cases, noting that Nilo's DNA was seized after he attended a private event at a restaurant. In the McClendon case, for example, prosecutors matched DNA from under Tremblay's fingernails to McClendon after he willingly gave a DNA sample. And in the case of the Jamaica Plain man, Brian Keyser, the DNA was abandoned, a loophole that allows investigators to get DNA without a warrant. So what happened with McClendon getting acquitted? We may be looking at activity versus action, or DNA being present versus activity. That's a good case to look at too. I need to look at that one. But Nilo did not abandon the glass or dinnerware, Scapiccio said, arguing he had no opportunity, I don't mean to laugh, to take the items with him out of the restaurant that night. No, you go to a restaurant or do an event and you touch the card swipe machine, you touch the napkins, you touch the stuff. You have no expectation to take that stuff home. just like you touch everything. The train, the subway. The public should be terrified. If it happened to Mr. Nilo, it could happen to anyone. None of us are safe going out to dinner. It's true. Surreptitious DNA. But you could he could have brushed up against the FBI agent and deposited his DNA. In theory, like a pickpocket, think about a pickpocket, not to be a pickpocket, but you know how they get close. We've seen them where they're really good at it and you don't even know that your wallet's missing or whatever. I guess we can start training our agents to be like close contact touchers and get the DNA. But what would happen? What would she be arguing? Again, we're just theorizing here. What would she be arguing if what happens if he touches the door or the FBI agent bumps up against him and he puts his hand up on the FBI agent and they get it? What happens if the FBI agent is sitting next to him at the dinner and he says, "Could you please pass the bread?" And you're going to get it because we have transfer DNA, right? It's all the time. My hair ends up everywhere, right? My friends and relatives probably have it all over their car, in their house, and whatever, just because it falls out and it gets everywhere. Once again, thank you for being here. I appreciate you liking, subscribing, and sharing because part of what you do here helps me donate my services to work on these rape cases, these unknown human remains cases, and these unsolved violent crimes. So thank you. I really appreciate it. Can't do it without you.